Hey there, this video is going to be about how to get a restraining order lifted in a criminal case as the alleged victim. My name is Veronica. I am a criminal defense attorney here in Los Angeles, and I help people who have been arrested put their criminal cases behind them so that they can enjoy their lives and their freedom. And again, this is going to be about how to get a restraining order lifted in a criminal case as the alleged victim. Now, if you are watching this video, then you probably already know that at the first court date in a domestic violence case, the prosecution in Los Angeles, but as far as I know, throughout the state of California, has a policy of always requesting a restraining order. And there are many times when the alleged victim of a domestic violence case is there and is saying to the DA, to the prosecutor, hey, I don't want this restraining order though. I need him or her at home. You know, nothing happened. The police got it wrong. They wouldn't listen. And that can fall on deaf ears. And many times, especially, you know, if you have a court-appointed attorney who doesn't have a whole lot of time to talk to you as the alleged victim or refuses to talk to you, you really can't do a whole lot about that at that first court date without having some knowledge. So there's going to be a restraining order in place at that point. Now, this advice that I'm going to give does apply to that first court date, and it also does apply if there's already a restraining order, okay? So, as the alleged victim of a crime, you have a right to request to be heard at court in the criminal case. So what you need to do if there's a restraining order already in place is show up for the next court date. If there has not been a restraining order issued yet, there's not been court yet, you need to go to the first court date and be ready to tell the judge 3 things. And when I say you have a right to be heard, so I, as a private criminal defense attorney, if I'm speaking to the alleged victim, I'll make sure that I say, hey, you know, Your Honor, the alleged victim's here. She does not want a restraining order to be issued in this case, and she would like to be heard, to give you that chance. The district attorney should be doing that if the defense attorney isn't doing that. But you can also even just flag down the deputy. If both of those people really won't talk to you, just flag down the deputy and tell the deputy, and the deputy will make sure that the clerk knows. So you're going to need to stand up and tell the court 3 things, okay? The first is that you do not want a restraining order to be issued in the case, or that you want the restraining order to be lifted if it has already been issued. The second thing is that you are not afraid of the defendant. And then the third thing, and this part may sound counterintuitive, but this is exactly what you need to say. If something were to happen in the future, if there was any violence, then you would call 911. That is what the judge needs to hear by statute. Now, you may think, but Veronica, I want to explain my side of the story. I want to explain that that night, actually, I was the aggressor. No, no, no. The reason why that is not helpful is because that's not what the judge needs to look at. The judge needs to hear that you don't want this restraining order. The judge needs to hear that you're not afraid of the defendant, and the judge needs to hear that you would call 911 if anything were to happen. Those are the 3 things that the judge must hear. If the judge does not hear those things, then the judge cannot lift the restraining order. And what's going to be irrelevant from you as the alleged victim at that time is your side of the story. Nobody wants to hear it at that point, and I'm sorry to say that, but the reason is because it's irrelevant. Now, what seems extra unfair is that the prosecution gets to, when they're arguing in favor of this restraining order staying in place or being issued in the first place, the prosecution gets to talk about the stuff that's in the police report. So the things that the police wrote down that may or may not be true. So you may be thinking, hey, that's not fair. I want to give my side of the story. Now is not the time. The reason is that for these restraining order hearings and for things like bail reduction, the judge has to assume that everything in the police report is true. It sucks. It's stupid. But blame the legislature. It's not the judge's fault. It's not the DA's fault. It's definitely not the defense attorney's fault. Just keep these 3 things in mind. If you have questions about this, if you are an alleged victim of a criminal case in Los Angeles and you need help, you can call criminal defense attorneys. You can book a consultation with me. You can also, call my office. But criminal defense attorneys, many times we will get calls from alleged victims who really don't want the charges to continue whatsoever, and certainly don't want a restraining order. And we can definitely help you on a more case-by-case basis in terms of what you need to say. I hope that you found this video helpful. And again, if you do need a consultation, feel free to give me a call, or you can click on the link right down below.